Video put on. So here we are. This is Admiralty Law. We are in Module 8. Whatever module is towage and pilotage. It is October 6, 2025, Section 1, around 4:30 p.m. And we're going to talk about pilotage first. The key things to remember is that pilotage is, first off, pilotage is a very complex area of the law in terms of federal and state regulation. Both the federal government and all of the state governments and states that have a coast and ports regulate pilotage in one way or another. And the interaction is very complex, and you don't really need to understand it unless you have an interest. There's some description in the text, and really the text is a very surface description of the complexity. But what is important, by the way, we watched the short film that I advise anybody who's not been present for these sessions to watch. It's, there's a link in the module materials, and it just is an introduction to pilotage and what pilots do. Moving back to the text and the subject matter at hand, we have this interesting dynamic about liability for when something goes wrong, like if a pilot has a collision, it should be an allision with a bridge, say, and the liability can be huge. Bridge got cut in half in Tampa, Florida, for example, in 1980. 11 people died. The damages to the bridge were in the millions. It definitely was a multi-million-dollar incident. The vessel didn't have much damage, unlike the one in Baltimore more recently, where a lot of the bridge material came down on deck. But even then, the dolly wasn't that badly damaged. But in any event, the liability, the parties who are on the receiving end of the collision, including the infrastructure of the port, could be bridges, whatever, and human lives, the liability can be huge. So who pays? Well, this comes down to the question of, in the first instance, is it compulsory or voluntary pilotage? And we covered that when we talked about the recording. We're going to go through it again real quick. The idea is that the various states that have ports, they regulate pilots related to the particular ports. And they might require that all vessels over a certain tonnage going in and out of the port must have a pilot. And that's somebody who knows the harbor and is licensed under both federal and state law. And they have to have a pilot when they come in and out of the port. So those are called compulsory pilots. There's actually criminal sanctions in most cases if they don't. It's not just a matter of paying a fine. It might be, somebody in the company might even get locked up. But those are not the details that are important. What's important is if it's compulsory, the owner of the vessel doesn't have a choice whether or not to hire a pilot. The alternative is where it's voluntary, which means that, we think our captain knows the port well enough, we're not going to bother hiring a pilot. Or they say, well, the captain doesn't know the port that well, and maybe we'll hire a pilot. So the state is not regulating that aspect of pilotage, and in that case, the pilot is voluntary. If the pilot is voluntary, the pilot is working for the ship owner. It's the employee, he or she is the ship owner's employee. And in most employment situations, if an employee does something negligent, the employer is held accountable for that. And that's that Latin phrase I have up here, which is also in the text, respondeat superior, which basically means the superior, the owner, the one up on the food chain, must respond, meaning they get sued and they have to cover that loss if they're found liable, even if it's the employee who makes a mistake. So in voluntary pilotage, if the ship owner decides to hire a pilot and the pilot cuts the bridge in half, the ship owner can be sued in persona, as distinguished from the ship being sued in rem. So this relates to in personam liability. Maersk clients, whatever, any company that owns the ship, not just the ship itself. And this exists in the voluntary pilot situation. Respondeat superior. Now, what about the compulsory pilot situation? Well, they didn't have a choice. They had to have a pilot. Do we think that this stuff will apply in compulsory pilotage? No, the courts are very clear on that. If you're forced to take on a pilot, you didn't voluntarily hire the pilot, So respondeat superior does not apply. And so that's all out. And so is this. You can't sue the ship owner. The vessel cuts the bridge in half, causes millions of dollars damage and 11 deaths. Nobody gets to sue the ship owner. Do they still have a party to sue? Yes. They can sue the vessel in rem. We have begun to touch the tip of the iceberg on in rem liability, but we already know that a ship itself can be a defendant. The ship can be arrested, the federal court has jurisdiction over the ship, and the ship itself can be a defendant in a maritime proceeding. And the ship, assuming it didn't also get sunk in the course of the elision or whatever, if it hit some rocks and a bridge, it might be under the water. But assuming the vessel is still around, it might be worth quite a few $million. And so the in rem action of the vessel can, in fact, proceed in a compulsory pilotage situation. That's a very important distinction because it ties into all these other things we're talking about in this course. In rem jurisdiction, and the respondeat superior bit is something we'll see a bit more of. But it's actually something that you want to know about for just general legal purposes. So if the employee at a department store mops the floor with something that's really slippery and doesn't put out those warning signs, and you slip and fall, assuming you're not an employee, then you're going to have that workers' comp problem. But assuming you're just a customer and you slip and fall and get badly injured, the employee's negligence will impute to the employer. So Macy's or Sears doesn't exist anymore, and Macy's barely exists, but one of these store owners, could be anybody, can be liable for the employee's negligence under respondeat superior. So that applies in the voluntary pilotage situation. The ship owner decided to hire a pilot, and if the pilot's negligence causes damage, the ship owner can be sued in persona, as opposed to in rem. I'm not going to write in rem down because these little links here tie into voluntary pilotage. Voluntary, you have respondeat superior, and you have in personam liability. I will write liability. But if it's compulsory, we'll just put that over here. Compulsory pilotage, no respondeat superior, but you do have in rem liability. That's with a compulsory pilot. Now, I'm sure all of you are asking, what happens to the in rem action if it's voluntary? Do you get to sue the owner in personam and the vessel? Sure. No reason not to. Why not? If I were the plaintiff's lawyer, I would be suing both the vessel in rem and the owner in personam, and maybe the pilot too. But that raises an interesting question. Is it usually worthwhile to sue the pilot individually? The pilot might have been totally negligent. Why not sue the pilot? Well, you can. But are you going to get any money? Probably not. Most pilots in the US are very well aware of the potential liability, and they make themselves asset-free. Their spouses typically have all the assets of the family in the spouse's name, and so the pilot, who has good earnings, has no assets. So that discourages plaintiffs from suing the pilot, but even if they do, the pilot probably has some kind of coverage for the legal expenses, might be through the pilot association, might be some private insurance that the pilot has hired or purchased, but there won't be any basic big hits to the pilot because, even if they get a judgment, the pilot can't pay it. And the legal fees might be expensive, but if they do get sued, because they still have to appear and defend, but that might be covered by some kind of insurance. So generally speaking, the pilots tend to be asset-free, and this discourages people from even bothering to sue them. And if they do, presumably, if they manage their affairs pretty well, they have some kind of coverage to pay for their legal defense. And at the end of the day, after they pay the lawyers, the plaintiffs probably won't get anything because the pilots don't have anything. But that's an important distinction. Another one, and we're not going to get heavily into regulation, on the state and federal level and all that stuff. One thing to keep in mind, there's a case cited in there, not a Supreme Court case, a Ninth Circuit case that says courts have upheld exculpatory clauses. Exculpatory means, in reference to a clause in a contract, a clause that relieves or purports to relieve a party from liability. Exculpate. take away the culpability. So that's the Latin root, the CULP part. And you can have some clauses in pilotage contracts that relieve pilots from liability. We're not going to do more with that than just say that they exist. There's a Ninth Circuit case cited. You don't have to read the Ninth Circuit case. I haven't read the Ninth Circuit case. But what I'm getting at here is that courts do, to some extent, enforce exculpatory clauses in pilotage contracts. The nature and extent of that possibility we're not going to explore at all. But it is a segue point to towage. Towage and pilotage are both very short chapters in the reading, and I encourage you to read those. I encourage you to read everything, but that would be, and you don't really have to belabor the points we're not going to get into. And there's also in the exculpatory thing in pilotage, it says exculpatory and benefit insurance clauses. Don't worry about the benefit of insurance clauses at all. And the only thing you really need to be aware of is that, in contrast to towage, pilotage contract exculpatory clauses can be given some recognition by the courts. Now we look at towage contracts, and you will see in the reading that there really is no way for a tug owner to relieve itself of liability for its own negligence. And there are several ways they try to do that. One is, an exculpatory clause that straight out says, no matter what we do wrong, we're not liable. That's one attempt. The court said no. Uniformly, the courts have said no. And if you can do another thing where you say that the tug personnel are the borrowed servants of the tug. So I have a tugboat, got a couple of mates, a captain, deckhand, engineer. I can say in the contract, under this contract, the barge owner, the tow, agrees that they are borrowing these servants, and they're your servants now. They're not people anymore. They're really yours. I'm paying them and everything, but they're the borrowed servants. So then, of course, if they mess up under respondeat superior, the theory would be, well, they're liable because they were your borrowed servants. That doesn't work either. The court saw right through that, and so this borrowed servant doctrine goes out the window, just like the straight-out exculpatory clause. Towage contracts cannot contain exculpatory clauses under U.S. law. It's, maritime law is well developed in this area. Again, not by statute, just cases, but the cases are uniform throughout the country that you can't relieve yourself of your own liability for towage. If you are the tugboat operator, you'd better, expect to be accountable if you do some harm to the barge or other property, and it's the fault of your personnel. You can't say, oh, it's the barge's fault. Now, there are exceptions to that. If the barge is unseaworthy and that's what caused the problem, and the unseaworthiness is not obvious when the tow took it on, that's a little different from an exculpatory clause. That's where there's clear liability on the part of the barge owner. And there's some nuances of that in the reading, but I don't want to get into it too much at this point. We'll maybe revisit it before I finish recording. But bottom line is, in contrast to pilotage contracts, towage contracts uniformly cannot get away with exculpatory clauses. Those clauses that purport to relieve the tug of liability, the courts have just thrown them out. Void, as if they didn't exist. There's an interesting exception to everything I just said about exculpatory clauses. Imagine this. Suppose you have a tug contract, a towage contract that has exculpatory clauses. It says, under no circumstances will the tug be liable even for its own negligence or reckless behavior. And it also says our employees on the tug are all the borrowed servants of the barge owner, and the barge owner signs that contract with all those clauses in it. And of course, under U.S. law, that would not apply. But down at the final clause of the contract, it says this contract will be resolved under the laws of Zamunda, and a court in Zamunda will adjudicate it all. And lo and behold, the Zamunda laws and the maritime law of Zamunda and its courts have uniformly accepted exculpatory clauses. So believe it or not, it's a little sneaky lawyer trick to get around the ban on exculpatory clauses in towage contracts, and it's mentioned in a footnote. I mention that because a lot of people who are getting into contract negotiation, they don't think too much about what law is going to apply and where it's going to be adjudicated, but those can be very important questions if there's a dispute later. So towage is an example of where the lawyers can really pull a fast one. And of course, it's not the only example, but what I'm advising you as consumers of legal service, whether professionally or personally, if you're getting into a contract, you might want to think about those forum selection clauses and choice of law clauses, because if they are for a place other than a place you're comfortable, and Zamunda, of course, is a made-up country from Coming to America with Eddie Murphy and Arsenio Hall, movie from the, I guess, 90s or 80s. You know, if it's a foreign country and, you know, the law of some other country is going to apply, you might want to look into that before you agree, because that might change all kinds of stuff. They said, I don't have to worry about this clause, it doesn't even apply in the U.S. Well, it applies in Zamunda or whatever other forum they choose. So that's a little exception to the exculpatory clause thing in towage. It's a rare one, but there's a citation to a situation, a case in the text that's sort of a reminder that that can happen. Now, let's shift back to towage contracts in general. I have a client who has, or actually just sold his tugs and barges, but he had a couple of tugs and a couple of barges. And what he did, it was called American Petroleum. I mean, he still has a company, it's still American Petroleum, but the tugs and barges belong to another outfit now. Anyway, the new outfit is doing the same thing. They're towing petroleum products, they're tanker barges, they're towing petroleum products around New York Harbor, and they own the tug and they own the barge, and they buy the petroleum and resell it, or deliver it, you know, so much per move, and they own the tug and the tow. Is that a towage situation? It's towage in terms of they're towing something, but for contract purposes, is a towage contract involved? Anybody think yes? Anybody think no? The very first words of the chapter on towage indicate that you have to distinguish between a towage contract and a contract of affreightment, A-F-F-R-E-I-G-H-T-M-E-N-T. Basically, if the same company owns the tug and the barge, it's not a towage contract situation. They're not contracting with anybody. They're towing their own stuff. They may be towing somebody else's cargo on the barge, but that's different. So that would be a contract of affreightment if it's somebody else's cargo, but it's not a towage contract. They're not towing an object, a barge or maybe a dead ship that belongs to somebody else. They're towing their own barge. So that's not a towage contract. Now, what about the duties of the tug and the duties of the tow? Do you need to spell those out in detail in the contract? Generally not. Why not? Because the law has evolved so much in towage that they're pretty much all set forth by law. And they're common sense things. I'm not going to go item by item. They're in the reading, but I mean, for example, the tug has to provide a seaworthy, vessel, and they have to obey the rules of the road. And if the barge is about to sink, they have to make some effort to try to prevent that. And when they take the barge, they have to do some kind of visual inspection to see if it's seaworthy. They don't have to do a detailed inspection with divers going underwater, checking the hull with instruments to make sure it's got the thickness that's required. They don't have to do all that, but they can't take a barge. If they take a barge that's listing to one side and you can see a hole right around the water line on the hull, that would be a breach of the tug's duty, right? The tug owner has to make sure that the barge is seaworthy, at least by, obvious standards, looking at the thing. If it's listing to one side, or if it looks so rusty that you can't believe the hull is still intact, or if it looks so top-heavy that it looks like it'll capsize the minute you move it, that would be an obvious unseaworthy condition, and the tug owner has a duty not to take the barge under those situations. But that duty doesn't get extreme. They don't have to, do a full inspection of the barge, because otherwise you couldn't even get into a towage contract without hiring all kinds of surveyors and stuff for the barge. It would be, ridiculous. So there is some duty of the tug owner to inspect the barge, but it's not that detailed. Does the tow have a duty to provide a seaworthy vessel? Of course it does. The barge has to be seaworthy. And if they breach that duty and the barge sinks, it's not the tug's fault, right? A lot of this is just common sense. Do I have to put all that into the towage contract? Well, this particular client that I mentioned did have a barge being delivered up the East Coast from Louisiana when it was being built or bought. And I wrote a very detailed contract with all that stuff in it. And then that was before I started teaching here. And I started looking at this chapter and I said, well, I guess I don't have to put in all those details. So the thing about towage contracts is most of the duties for tug and tow are imposed by law based on general maritime law that came from the courts over many cases. So you really don't need to have a detailed listing of all the duties if you don't want to be bothered. Really all you need in a towage contract, it'll look kind of bare bones, just from where to where, what time frame, how much, that kind of thing. If there's special circumstances, you want to put those in the barge. You know, if the barge has particular seaworthiness issues and you're still going to take it as a tug, you may want to have some indemnity provisions so that, language like tow is aware of such and such conditions, and should any such conditions cause loss of the barge, clearly, or liability of third parties, the barge is responsible for those and hereby indemnifies the tug owner, blah, blah, blah. But that's sort of the special circumstances. Generally speaking, a towage contract can be pretty bare bones, and the duties imposed by law cover just about anything. Cover just about everything in terms of the duties, the standard duties for tug and tow. And I gave you, a little quick talk about what those duties are. I mentioned more of the duties of the tug, but they're all in the reading, and they're all material that you'll want to be familiar with, both for the course overall and particularly for this next 25-point quiz, test, whatever you want to call it, that's going to be released in a day or two. Okay, let's pause. I'm going to use this. And so, France, 1789, French Revolution. They're cutting off a lot of heads. And there's a whole line of people waiting for the guillotine. And the first one up is a priest. And they put the priest's head in the proper position, and they pull the cord, and the blade comes down and stops, 5 feet above his head. No, 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 you must free me. God has decreed that I must not be killed. It is the will of God that I be released. Okay, go. So then they put in the next one, who's a lawyer, and they pull up the blade, and they release it, and it stops in the same place just before, 5 feet above where the guy's neck is. And he says, you cannot put me in jeopardy twice. You must free me. And so they free the lawyer, and then they put in the engineer, and they pull up the cord, and they release it, and the blade stops, and the engineer looks up and says, I think I see where the problem is. Okay, it's a wrap.